If you have ever walked into a federally licensed gun dealer in New Jersey and been told a rifle sitting right there on the wall was simply illegal for you to buy, that conversation just changed, and most people in the state still do not know it happened. On July 17, 2026, the full United States Court of Appeals for the Third Circuit, sitting en banc, ruled 10-5 that New Jersey's ban on so-called assault firearms and its ban on magazines holding more than 10 rounds both violate the Second Amendment. This is not a state legislature quietly amending a bill. This is the highest federal court covering New Jersey striking down two of the state's core firearms restrictions in a single, sweeping opinion. If you own guns in New Jersey, want to buy one, or you are just trying to understand what is actually legal right now versus what used to be illegal a few weeks ago, stay with me, because the practical answer is more specific than either the celebration headlines or the panic headlines are giving you. Before we get into exactly what changed and what is still uncertain, if you live in New Jersey or any state with similar restrictions, hit subscribe right now because this ruling is part of a much bigger fight heading to the Supreme Court within months, and I track every development the moment it happens. Drop a comment telling me whether you think a rifle's popularity across the country should be the deciding factor in whether a state can ban it. That is genuinely the core question this case answers, and I want to hear where you land. Let's start with the case itself. It is called Association of New Jersey Rifle and Pistol Clubs versus Platkin, docket number 24-2415, decided by the full Third Circuit sitting en banc on July 17, 2026. Judge Ariana Freeman wrote the majority opinion, and Judge Patty Schwartz wrote the principal dissent, with the full package of opinions, concurrences, and dissents running roughly 192 pages, which tells you just how contested and thoroughly argued this case actually was inside the court itself. The lead plaintiff was the Association of New Jersey Rifle and Pistol Clubs, the state affiliate of the National Rifle Association, joined by the Firearms Policy Coalition and several individual gun owners, including Blake Ellman and Mark Weinberg, who were named plaintiffs in the underlying lawsuits. The NRA funded the litigation, and its counsel argued the case before the full court. This case had actually been working through the federal court system since 2018, and the ruling you are hearing about today consolidated 3 separate related lawsuits challenging different pieces of New Jersey's firearms restrictions, all rolled together into one comprehensive appeal. New Jersey's law at issue here, called the Assault Firearms Act, dates back to 1990, and it prohibits possession of dozens of specifically named semi-automatic rifles, pistols, and shotguns. Along with any firearm the law considers substantially identical to those listed, unless you hold a limited state-issued license. Separately, the state has restricted magazine capacity since 1990 as well, originally capping magazines at 15 rounds, then amending the law in 2018 to lower that cap to 10 rounds. At the district court level, a judge had already found New Jersey's specific ban on the Colt AR-15 unconstitutional, but upheld the broader magazine capacity restriction and rejected a separate claim that the magazine law amounted to an unconstitutional taking of property. Both sides appealed that mixed result, which is how the case ended up in front of the full Third Circuit. Here's where the ruling gets significant, and this is the detail that most headlines flattened into something simpler than it actually is. The Third Circuit did not just affirm the narrow district court ruling about one specific rifle model. The majority wrote that it agreed the ban on Colt AR-15 specifically violates the Second Amendment, but then went further, stating that because the record supported the same result for semi-automatic rifles generally, not only Colt AR-15, the court would modify the order to apply more broadly across the entire category the state had banned. On the magazine question, the court reversed the district court entirely, striking down the 10-round cap and finding that magazines capable of holding more than 10 rounds are commonly possessed by law-abiding Americans and therefore fall within what the Second Amendment protects. The legal reasoning underneath this ruling follows the same historical tradition test the Supreme Court set out in its 2022 Bruin decision. Under that framework, the court first asks whether the item in question counts as an arm under the plain text of the Second Amendment, and the majority found that semi-automatic firearms clearly qualify because they are firearms, and that magazines qualify too because they are necessary to actually operate many of those firearms. From there, the court asked whether these items are, in the language of the test, in common use by law-abiding citizens for lawful purposes, and found that they are, given how widely both semi-automatic rifles and magazines above 10 rounds are owned across the country, citing figures on national ownership rates that the state itself did not seriously dispute. New Jersey tried to defend its magazine restriction using historical comparisons, pointing to old surety laws, which required certain individuals to post a bond promising to keep the peace, and early regulations on Bowie knife commerce as evidence of a tradition of capacity-style restrictions on weapons and their components. The majority rejected both comparisons in detail, finding that surety laws addressed dangerous individuals rather than dangerous equipment, and that early Bowie knife regulations addressed commerce in a specific weapon entirely unrelated to ammunition capacity in a modern firearm. Neither historical example, the court concluded, actually addressed ammunition capacity in any meaningful way, which meant the state had failed to show the kind of close historical match Bruin requires before a modern restriction can stand. Now let's talk about what actually changes for you if you are a gun owner or buyer in New Jersey. The Third Circuit issued its opinion without a stay, meaning the ruling took effect on its own timeline rather than being paused pending further appeal. New Jersey State Police notified federally licensed dealers that the old rules, the assault firearm list, and the 10-round magazine cap remained in effect only through July 31, 2026. Beginning that date, dealers were told they can process transfers of AR-15 pattern rifles and magazines holding more than 10 rounds to New Jersey residents who otherwise pass the state's background check and permit to purchase process. Picture a resident who tried to buy a duty-configured AR-15 with a collapsible stock and a 30-round magazine back in June, before this ruling came down. Under the assault firearm feature test New Jersey used at the time, that exact configuration would have been flatly illegal to sell, no matter how clean the buyer's background check came back. After July 31st, that same configuration is legally available for transfer to a qualifying resident, purely because the underlying ban and the magazine cap that made it illegal no longer apply. If you have been waiting to buy a rifle that was previously on New Jersey's banned list, your action step is straightforward. Contact a licensed dealer directly and confirm current inventory and paperwork requirements, because the standard background check and permitting process still applies even though the weapon category itself is no longer prohibited. There are two important limits you need to keep in mind before you assume this ruling settles everything. First, this decision specifically addressed semi-automatic rifles and magazine capacity. It did not address New Jersey's separate restrictions on semi-automatic pistols and shotguns, which remain the subject of ongoing litigation the Third Circuit did not resolve in this opinion. If you are looking at a banned pistol or shotgun model rather than a rifle, do not assume this ruling covers it, because it explicitly does not, at least not yet. Second, and this matters enormously for how long any of this stays settled, New Jersey is expected to seek Supreme Court review specifically to keep its ban in effect while the state pursues a full appeal. And the vote inside the Third Circuit itself was 10-5, meaning 5 judges dissented and argued the majority overweighted a weapon's popularity while understating the state's interest in restricting rifles used disproportionately in mass shootings. That dissent is a real signal that this fight is far from finished at the appellate level, let alone at the Supreme Court. Which brings us to the biggest piece of context you need. This ruling did not happen in a vacuum, and it directly deepens a split among federal appeals courts that the Supreme Court has already signaled it wants to resolve. The First Circuit previously upheld Massachusetts' assault weapons ban, and the Seventh Circuit upheld a similar Illinois ban earlier in July of this same year. That means different federal circuits are reaching opposite conclusions on essentially the same legal question, and on June 30th, 2026, the Supreme Court already granted certiorari in 2 consolidated cases, Viramontes v. Cook County and Grant v. Higgins, both asking whether the Second and 14th Amendments protect the right to possess AR-15 platform rifles and similar semi-automatic firearms. Oral argument in those cases is expected this fall. Your action step here is simple. Do not treat the current New Jersey rule as permanent in either direction, because the Supreme Court is very likely to issue a nationwide answer to this exact question within the next year, and whatever New Jersey's current status is, could shift again depending on how that ruling comes down. Step back and look at the full picture. A federal appeals court just struck down a 36-year-old state law covering an entire category of commonly owned rifles and standard capacity magazines, using a historical test that requires the government to prove close, genuine analogs rather than vague comparisons. That is a significant ruling on its own, but it is really one data point inside a larger national collision between circuits that the Supreme Court is now positioned to resolve directly. The Justice Department itself filed a brief supporting the gun owners in this very case ahead of the en banc rehearing, which is a meaningful signal about which direction the federal government currently leans on this exact legal question. Whether you are a gun owner in New Jersey trying to figure out what you can legally buy today, or you are watching this from another state entirely with its own assault weapons or magazine restrictions still on the books, the coming Supreme Court term is going to answer this question for the whole country, not just for one state's specific statute, and that answer is likely to arrive faster than most people expect, given how directly the circuits are now conflicting. If this actually clarified what changed in New Jersey instead of the oversimplified headlines calling it either total victory or total disaster, hit that like button so more people find the accurate version. Subscribe, because the Supreme Court argument in the AR-15 cases this fall is going to be one of the most consequential Second Amendment moments in years, and I will be breaking it down step by step as it happens. Drop a comment telling me whether your state has a similar assault weapons or magazine law on the books, because there is a real chance your state's law is next in line for exactly this kind of challenge.